Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, a few days ago I did this video right here where we geeked out about this little obscure case that came out of Massachusetts, but man, the ruling is really awesome. And so to set this all up, let me just ask all of you questions here. And the question is, you know, y'all got a First Amendment right to speak whatever you want, go practice whatever religion you want. You got a Fourth Amendment right to be free from unreasonable searches and seizures. You got a Fifth and Sixth Amendment right to due process. You got an Eighth Amendment right to be free from cruel and unusual punishment. Do you only get to enjoy those rights if you're inside your home state? Or do you actually have those constitutional rights no matter where you go? Well, we all know the answer. I know one of you are saying that's kind of a dumb question, okay? But then let me ask you this question here. What about your Second Amendment rights? Do they terminate once you get to a state border? Because the answer is yes, they do. In many instances, you can no longer carry a firearm for self-protection once you get to another state unless you have some sort of reciprocity agreement or an out-of-state permit, or you've gotten the blessing from the governor and their attorney general or whatever else it may be. Well, this case in Massachusetts raises a lot of very interesting questions that we should all start asking and questions that really deserve to be answered. So today, let's talk about why this is so important, because this is the case for national constitutional carry. Okay, so the case we're talking about again today is Commonwealth v. Donnell. This is a case that came out of the Sussex District Court in Massachusetts. Mr. Donnell, a resident of New Hampshire, was in possession of a firearm which he lawfully owned, lawfully possessed, had jumped through all of the hoops, whatever New Hampshire has in the way of hoops to become a lawful, responsible gun owner. He'd done all of them, but then had the audacity to cross into the state of Massachusetts while still carrying that firearm. Of course, he didn't have a Massachusetts gun permit and was charged with a crime. A crime, by the way, which would have carried mandatory jail time. Now, there's no allegation that he did anything nefarious once he got into Massachusetts other than carry the firearm, and yet he was still looking at mandatory jail time. Now, the trial court, in throwing this case out, basically finding the law unconstitutional, raised a lot of really good questions. And it's just questions that got me thinking, and I started geeking out with some other people, and I was like, hey, is this the beginning of the legal framework for why we need national constitutional carry? Now, let's outline something first. What is constitutional carry? Well, we've got 27 states now in the United States that have constitutional carry, which basically says, hey, listen, if you are lawfully allowed to possess a firearm, the Second Amendment says you have the right to keep and bear arms. And of course, there is a litany of case law out there that says bear arms means you get to carry it and use it in self-defense if necessary. So what constitutional carry states are is, listen, if you are otherwise lawfully allowed to possess a firearm, you can possess a firearm consistent with our concealed carry laws, which do not require licensing. There may be restrictions as to where you can carry them. Most states have that, but there's no licensing regime. Now, out here in the People's Republic of Washington, we actually have a okay licensing regime. We are a shall issue state as long as you pass a background check, which means you're lawfully allowed to possess a firearm. The state of Washington has to issue you a concealed pistol license. They have to do it within 30 days. The problem is if you live somewhere else in the United States and you want to come and visit Washington, don't do it. But in the case you did, unless you're from one of 9 states, you don't get to carry a firearm here in Washington state. Why is that? Because you are lawfully allowed to possess that firearm. You're lawfully allowed to carry that gun in your home state. Why is it that you can't carry a gun in our state? And therein lies the problem with all of this concealed carry reciprocity, which creates this hodgepodge, this tapestry of gun laws that nobody knows what to do with. And in fact, one of the most common questions that we field at Washington Gun Law is questions like, I live in state A, I'm visiting state B and state C, can I carry? And trust me, sometimes it is a long, convoluted research project. Why then is that the only constitutional right that you got to jump through all these extra hoops every time you move or go through another state, okay? Because there is no other constitutional right you lose in that fashion. Now, when the state of Massachusetts tried to argue that, hey, our laws are perfectly fine, and oh, by the way, it's not that he couldn't have the firearm, he couldn't possess the firearm while he was in Massachusetts, he just couldn't have it on him, he couldn't be actually concealed carrying it, okay? And that did not bode well with the court. As the court put this entire argument, As the defendant in the instant case is not a resident of Massachusetts and was in compliance with his home state's laws on possession of firearm, the Commonwealth needed to show some historical analog relating to disparate treatment of non-residents and must point to some historical precedent from before, during, or even after the founding that evinces a comparable tradition of regulation. And here's the problem for that, because we have a very rich tradition of banning firearms from people that we believe to be dangerous, and we have a very rich tradition of banning the possession of firearms in certain sensitive places. We have no tradition of a person suddenly losing their constitutional rights merely because they have crossed a state line. The Commonwealth points to no historical precedent limiting the reach of one's exercise to a federal constitutional right to only within that resident's state's borders. And like I mentioned earlier, the state of Massachusetts said, hey, listen, he could actually possess the firearm if he was in Massachusetts. He just needs to be locked in a case surrounded by barbed wire in the trunk of his car with an armed security guard standing outside. But as we mentioned before, remember, our right is the right to keep and bear arms. And there is a litany of cases that says the terminology bear arms means to carry arms and use if necessary for self-defense. This exception was not persuasive to the court when they found. However, the exceptions miss the point of the Second Amendment. The Second Amendment and the right to possess firearms is for personal protection, self-defense. The exceptions strip away the right by disarming the individual while he is traveling within the state. The Commonwealth does not point to any historical precedent for this. And then, of course, the state of Massachusetts argued, but you see, we have to run all these people through a very thorough background check to vet them to make sure that, they're suitable to be possessing a firearm. However, the court pointed out, wait a second, doesn't every single gun owner go through that exact background check when they fill out their Form 4473? Or as the court put it, the Commonwealth next argues that the Massachusetts licensing scheme imposes a permissible burden because of the substantial state interest in preventing certain people from possessing firearms. However, under federal law, certain people are prohibited from obtaining, possessing firearms. 18 U.S.C. Section 922G makes it unlawful for certain categories of persons to ship, transport, receive, or possess firearms or ammunition. And of course, we're all familiar with that section because that compromises almost every single question that is in Section 21 of the Form 4473. And candidly, when you take a look at what's happening in most states on a shall issue regime, and of course there is no such thing as a may issue regime. There are some that are still trying to revive it or resuscitate it, if you would. But the only requirements is that you pass a background check and therefore you are lawfully allowed to possess a firearm. Why then, if you go through that background check, if you were going to go to another state and buy a firearm, you'd be run right through the exact same background check. Why then do you lose the right to keep and bear arms by merely crossing a state line? And as I mentioned at the very beginning of this, and the court states it very eloquently as follows, this court can think of no other constitutional right which a person loses simply by traveling beyond his home state's borders into another state, continuing to exercise that right, and instantaneously becomes a felon subject to mandatory minimum sentence of incarceration. An individual only loses a constitutional right if he commits an offense or is or has been engaged in certain behavior that is covered by 18 U.S.C. Section 922. He doesn't lose that right simply by traveling into an adjoining state whose statutes mandate that residents of that state obtain a license prior to exercising their constitutional right. To hold otherwise would inexplicably treat Second Amendment rights differently than other individually held rights. So if that truly is the logic, why then should we tolerate all of these concealed carrying licensing regimes and our inability to carry anywhere except our home state? Is this not the perfect argument for national constitutional carry? And maybe it is time that we start having a significant discussion about federal legislation or even a constitutional amendment. Let me remind everyone that we have a governor in California who wants to have a constitutional convention about the 28th Amendment. Well, Governor, how about we add to that agenda a national concealed carry law? I will point out that there are more than a majority of the states in the country right now that are constitutional carry. That might be really interesting. Listen, you may have more questions about this case. constitutional carry, national concealed carry, or anything else related to what's left of our Second Amendment rights. Now, if you guys do, you should know how to contact Washington Gun Law by now, but if you don't, that's okay. That information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From Washington's nicest indoor shooting facility right here in Security Gun Club, thanks for watching. Stay safe.